the Coy Library. Oops. Oh, wait a second. Okay. So I'm going to give a little bit of background about the Pennsylvania judicial system. It is a tiered, I would say, system. Most people are familiar with the entry-level courts, which are in Philadelphia, it's our municipal court. And in every other county outside of Philadelphia, they are magisterial district courts. In Philadelphia, the municipal court they are judges, and in magisterial district court, while they're judges, they are run for 6-year terms. They technically do not have to be a lawyer. They have to pass an exam. Whereas in Philadelphia, the municipal court judges have to be a lawyer. They run an initial 10-year term and then run for retention. Above the municipal court and magisterial district court handles, as Petra will tell you, initial arraignments. They also handle certain civil matters that are under $12,000. So for example, maybe a landlord-tenant dispute, maybe a breach of contract dispute. If you have, after you've gone before the municipal court or the magisterial district court and you're not happy with the decision, for example, you want to appeal it, you then appeal it to a court of common pleas. The court of common pleas, depending on why you're there, has jury trials, whereas the municipal court and magisterial district courts do not have jury trials. The court of common pleas addresses, civil, criminal, family law matters. Again, if you are, if there's a decision or a finality or a jury decision with which you're not happy, you can appeal it, and the appeal is typically to the Superior Court, which is our initial, I guess, appellate court that is the busiest court in the country, believe it or not. We have a remarkable Superior Court. We have a majority of women on the Superior Court, which is also unusual. And they handle about 3,000 matters a year, 3,000 to 5,000 matters a year. Another appellate court that we have in Pennsylvania, which is unique to Pennsylvania, is a Commonwealth Court. It is a court where which handles matters brought by like state or districts or governments typically. And then when either the Superior Court or Commonwealth Court reach decisions and maybe a party is not happy, they can be appealed to the Supreme Court. That's our highest court in Pennsylvania. Supreme Court is known as a discretionary court so that it doesn't necessarily have to take the matter except for criminal cases of life sentences, or death penalties. So that's a quick summary of our Pennsylvania judicial system. And next, I ran through all this, Jeff. Okay, so why don't we skip ahead because I sort of summarized all this quickly without the slides. Go ahead. And we can get to the meat of the presentation. So this is so go back one more slide, Chelsea. Go back one. So I guess, Petra, do you want to take it from here?
Sure.
Yeah, okay.
So going back to talk about the way that our courts are structured, the best way I think is with examples of just what kind of stuff for criminal at least goes through those different bodies. So for a magistrate judge, which is the magisterial district court, which again, Philadelphia is its own entity,
right?
And it's just not something where I think any seasoned practitioner would even tell you to try to experiment by practicing down there if you don't do it routinely. They have entirely different rules. They have an entirely different procedure. It is all, it's just structured very differently. So everything I'm going to talk about is going to be except Philadelphia. So what this looks like is that when a person gets arrested initially, if they're actually physically arrested and taken into custody, they would go in front of a magistrate judge for something that's called a preliminary arraignment. The alternative to that is that a matter can be sent out what's called by summons, which means that you just get that certified letter in the mail. What's interesting about our rules for service are that for this one issue, they actually mirror the civil requirement that it has to be a official mailing, but then also just regular first class. And so what's important is whether or not that mail bounces back, because the number one rule for criminal court is that you have to be on notice. You have to be knowledgeable about what's being brought against you so that you have the opportunity to defend it. That is the very heart of our due process system. It's what everything is based on. So at the magistrate district court, the first thing that would happen is that preliminary arraignment, followed by then what's called a preliminary hearing. And the best way to describe a magistrate judge's duties are that they are essentially a gatekeeper. They don't have to be attorneys. They don't have to have that intense legal knowledge. They are really just looking for criminal elements. So an officer files a charge, and a DA is there to defend the charge having been filed. All the magistrate judge has to decide is, was all of the elements of that crime met? That's it. And what's unique about a preliminary hearing is that there's nothing about character. There's nothing about credibility that becomes relevant at that level. So just putting on someone as a defendant to say, well, that other person's lying. They've lied in the past. That's not relevant evidence for a preliminary hearing. And unfortunately, even if that's the case, that case is probably going to move forward into the Court of Common Pleas, because based on just a statement, it can be as little as one person, a magistrate judge is able to move a case forward. It's called dispositional transfer. They'll transfer it into the Court of Common Pleas. And once we get to the Court of Common Pleas, we're looking at judges that are all attorneys, have all been elected. They're sitting for 10-year terms, and they're only up for retention once their 10 years are up. It is very much the court that we all think of for that process. And that is where we have trials. It's where sentences are handed down the way we traditionally think of that. It is where pleas would happen for bigger offenses that are not just traffic tickets or something smaller like that. Next slide. All right, so this is actually something that I get questions about almost every time I have a case, is he didn't read me my Miranda rights. The officer didn't do this. So what's very interesting about this requirement for criminal law is that there is a context in which it has to happen. And if that context doesn't exist, it's not a requirement. Even though it seems like from every TV show you've ever watched, it's supposed to happen every time you meet a police officer, that's just not true. So where Miranda is required is when an officer, so a law enforcement officer, has you in custodial detention. And so it's that they're affecting their authority as law enforcement, and they have officially detained you. You're not free to leave. That's basically the magic phrase. In that context, they have to Mirandize you if they're going to question you, and if they want to try to use any statements that you're going to make against you, because that is the only thing that Miranda protects you from, is that right against self-incrimination. It's your Fifth Amendment right for the United States Constitution, and we also have that codified in our Pennsylvania Constitution as well. And so that is really the only protection. If they fail to do that, so if a police officer has you in custodial detention and they're questioning you, they're interrogating you, and they don't read you your Miranda rights, the way to cure that, the way to solve that problem and discipline the officer is actually to suppress your statement. So it means that they don't get that evidence that they collected illegally. That's what a suppression hearing is. And that's something that a Court of Common Pleas judge would have to decide prior to a trial ever even happening. As far as being able to search you, there are certain things that happen. So when a police officer comes in contact with you, there's three ways that they could be engaging with you. One is called just a mere encounter. It's just that a police officer walks up to you on the street like anyone else and just tries to talk to you. You have no obligation to speak with them in that context. It's just any other citizen walking up to another citizen. That's a mere encounter. Then there's something that's called reasonable suspicion. And what that means is that the police officer has to have observed something or have knowledge of something that arises a reasonably articulable suspicion that criminal activity is afoot. So they basically have to describe why you standing on the corner could lead to criminal conduct. They have to have a reason for it. It can't just be a gut feeling. It can't just be an instinct. It can't just be, quite frankly, the corner that you're standing on.
And can you ask that authority what their reason is?
Yeah, absolutely. They don't have to tell you. But yes, you can absolutely ask. There's nothing that keeps you from inquiring. But they do not have an obligation to relay investigative strategies to you, or even, quite frankly, what they're thinking about at the time. Once we get past that, let's assume they can articulate a suspicion to just stop you for a moment. The one thing that we see this with almost always is a DUI, is that they see you driving erratically and they're like, well, something's up. And so they'll pull you over and they'll complete a stop. And they can do that for one of two reasons. They can do it because they have a reasonable suspicion that you're driving under the influence, or they can do it if they have probable cause, which is a slightly higher standard. It's that a crime is probably happening and you're probably the one committing it. Probable cause that a traffic violation is occurring. Those are the two reasons that an officer would be allowed to stop your car, other than having a warrant that they're trying to serve on you in the process of it. But in that event, if they are stopping you for a DUI, that's why they start to ask all the questions about, how much have you had to drink tonight? Where have you coming from? Who were you with? Please step out of the car. Let's do some field sobriety tests. So for them to even get to that point, though, for them to even pull you out of the car, if the only basis is reasonable suspicion, they have to be able to articulate why they're allowed to take that custody of you, okay? They have to be able to articulate why they're even allowed to ask you to submit to those tests. And then in order to actually get a blood draw from you or to even ask for your submission for testing, that again goes back up to that slightly higher level of probable cause. As far as searching pockets, purses, bags, cars, all of those things, it really depends on, quite frankly, what court you're in. So our federal government has a very limited standard that I think most defense counsel would tell you has essentially eliminated our Fourth Amendment in the federal courts. It is so limited when you're in a vehicle. It's essentially that you have put yourself in public and that you are, now potentially subject to search. It is a very restricted limit. For Pennsylvania, however, our Commonwealth has its own constitution, and every state is allowed to give greater rights to its citizens within the state. And so we actually provide for more protection of our citizens than the federal constitution does in our protections. And so one of the things about car searches is the same as what we kind of just talked about as far as them trying to stop you for a DUI, trying to stop you for a traffic violation. They have to have either probable cause and a warrant, or you have to just randomly allow them to do so. And it is a completely voluntary consent is what's required. You have to say, I understand that you want to look in my car. I understand where you want to look, and I am agreeing to let you do it. It has to be a voluntary consent. But it's one of those two options that would get a police officer inside your vehicle lawfully. As far as a purse or a bag, it's going to depend on the context of what they're investigating and why. So that's a little bit more case specific, and I think I could probably spend 15 minutes on just that one. So I'm gonna skip that for a second. And then pockets. they are allowed to do if they can get you into detention. So if they're at the point for a DUI where they're taking you to go get a blood draw, you are in custodial detention, okay? And as a result of having arrested you, they are now allowed to do something that's called a search incident to arrest, which means that they get to check your person and your immediate vicinity, so your wingspan basically. And the purpose of this search is officer safety. They want to make sure there's not a weapon that you have access to, that you can't destroy any evidence, and that there's nothing that you're going to ingest on the way to whatever it is they're taking you to go do. But that is the scope of what they're allowed to do when they initially take you into custody, if they don't have a warrant and it's just an on-site arrest. Can I get the next slide? Okay, so preliminary arraignments, this is actually something where you don't normally have counsel here. The only time that this will become an issue is if somebody really has a good reason for asking for nominal bail, and quite frankly, if you can get an attorney active fast enough. This happens very quickly within hours of you being arrested. And so it is something that not very many people end up with counsel for, unless there's an investigation that's been ongoing that you already hired an attorney for. There are a few public defender's offices throughout the state that are actually starting the process of assigning public defenders to preliminary arraignments. But one of the key points where this happens is what we call night court, where judges sit on a rotating schedule, and these are the magistrate judges. They sit on a rotating schedule, and they're essentially on call basically all night for a set period of days, where anyone that's detained is brought before them at set periods of time to have bail set. And that's really the thing with preliminary arraignments, is it's bail or jail. So you're either getting detained or you're getting some kind of amount of money posted that if you pay it, you're going to be able to walk out. And when you're setting bail, there's a couple of ways that that can work. The least restrictive bail option would be something that's called ROR, or release on your own recognizance, which essentially says, Judge, I promise I am going to show up for all of my court dates. You don't have to worry about me, okay? That is usually something that is reserved for cases that are sent out summons, not usually things where it was serious enough to have gone out and put you in handcuffs and arrested you right on the spot. Slightly above that is something that's called unsecured bail. And what it means is that they'll set a dollar amount, for instance, $500, unsecured. And what that means is that you're walking out of there right then and there. You're going to sign a piece of paper that says, I or someone else is going to act as my surety. I'm going to guarantee that bail. And in the event that I break my promise to show up for court, I might have to pay the court that $500. But for now, you're going to take me at my word and let me go. Above that is what we just call cash bail. And there is a national fight going on about cash bail right now that is another hours-long presentation about how everyone handles this. But cash bail is what we normally think of, where a judge says, all right, $10,000. And then you have to decide, am I going to pay the whole thing if I can? Or do I need to go get a bail bonds person to post a percentage of it? Or can my family post a percentage of it and then use something else as collateral that the court might accept? And what's important about understanding the difference between those two things is that if you use a bail bonds person, that percentage amount that you pay to them, which you're considering it what you're paying for your bail, is actually their fee. The bail bonds person for a $10,000 bail might have you pay $1,000, but then they are actually putting up all $10,000 and guaranteeing that you will appear for court. So if you have the ability to pay your whole bail, then that is the only way you would actually get all of it back at the end of your case, once your appearance has been insured by it. If you hire a bail bonds person, whatever you pay to them is simply gone. It's just another cost and expense of court. I think I got all of that. Could I get the next slide? All right, and I think I talked about jail and bail. So basically there is no burden of evidence for bail. It's a question of whether or not you're a risk to yourself, which is essentially asking, am I going to harm myself? Do I have any history of self-harm? Did my conduct involve self-harm? Am I intoxicated to such a degree that I might harm myself? Am I potentially a danger to others? Is my crime violent? Do I have a history of violence? Do I have a mental condition that makes it so that I'm not trustworthy around myself or others? And the third is, am I a flight risk? Am I from here? Do I have connections to the area? Am I pretty sure that I'm going to be back for court? Those are really the three things that a judge has to say. You're fine on all of those in order to set that I promise to show up ROR bail, or even the unsecured bail, or a very low monetary bail. They are making sure that whatever it is, bail is the guarantee that you'll appear. Can I get the next one? Okay, and bail hearings, it says on here too that, I mean, they are happening all the time. So it is a ongoing rotating door where warrants get signed, police officers go out and pick up people and they bring them right in front of the magistrate judge. And within hours, sometimes quite frankly, within the hour of having been arrested, you're in front of a judge and they're deciding whether or not to let you go and what conditions they can put on you. And in addition to just cash bail or not cash bail, judges are allowed, magistrate judges are allowed, and so are common pleas judges, to set non-monetary conditions, like no contact orders, or to get a drug and alcohol evaluation, or that you'll have to submit to something called pretrial supervision, that you have to call in to the probation office, that you might have to wear an ankle monitor. There's lots of things that they could say, we don't think that money alone, or even not money, is going to solve the problem here. We're going to set a very specific behavior condition, and you're going to have to comply with that until it's either removed from your bail or your court case is over. Sometimes it is something where it's happening on a screen for night court and things like that. Oftentimes the judge will actually appear on a video monitor because they will, even before COVID, they'll be able to log in from their house and do it the same way that we've been handling everything, including this today. That was one of the systems that previously existed that allowed that 24/7, 365 schedule to occur. So they were sort of set up for COVID, not exactly when it started, but they at least had the tools. All right, so preliminary hearings. This is that gatekeeping hearing. It's asking the question very, very specifically, was law enforcement even allowed to have arrested you? That's the question. Did they have prima facie? Can they show probable cause evidence that all the elements of all the charges are met? Okay. And if they can't, it is the magistrate's job to say, you don't have it. You can't bring this. It's not allowed to go past here. And they're allowed to kick a charge. They can dismiss it. They have that authority. Anything from a traffic ticket to murder. A magistrate judge is able to say, you haven't met the elements. It's not moving past here. However, if a magistrate judge does that, it is within the Commonwealth's discretion, meaning the district attorney, attorney general, whoever your prosecuting agency is, to simply refile that charge. And they can do that as many times as they want to, up until the statute of limitations has run for a case, or in certain instances where there's another question of timeliness. But they're allowed to just keep trying and trying and trying and trying to get it through the filter. But that is the point of a magistrate judge, is that they are trying to keep the nonsense out of the real courthouse, in addition to all of their civil duties. And it gives you your very first chance as a defendant to see the allegations against you. So at a preliminary hearing, you actually have the right to have evidence presented. Sometimes it's not the way that we would all hope that it would be presented at a hearing like this, but sometimes it's just the officer getting up and testifying. Sometimes they'll actually show you some video footage from either their car cameras or their body cameras. Sometimes it's an actual victim coming in and testifying about alleged conduct. It just depends on the nature of the case and what the district attorney feels like they need to put on to get it through. So that is very much a decision that they have to make on their own. It's up to the judge to decide if they did it or not. And then as defense counsel, we have the right to cross-examine any of those witnesses. It is also not a court of record. And what I mean by that is that there's not a stenographer sitting there. It's not a recorded hearing unless someone specifically brings a stenographer or asks to record it. And so sometimes when you have more serious cases, that's exactly what a defense attorney or a defendant will do, is that they will either hire a stenographer to come or they will ask the court's permission to record the hearing. But because of our wiretap laws in Pennsylvania, you have to be granted permission to record a hearing. You can't simply do it. And you definitely can't do it what's called surreptitiously or secretly. You may never record court secretly. And beyond the preliminary hearing, you may never record court at all. It's actually a specific rule that we have for Pennsylvania.
And so that, I'm going to interrupt you for a second, because that actually presented an interesting dilemma during COVID, right? Because the court actually had hearings that were videoed by or shown by YouTube, but you were not allowed to record them, right? It is actually a violation of the law for you to record these hearings. So the court itself was in an interesting predicament during COVID.
Yeah. And that was part of why we had so many of those executive orders that existed from basically, which actually went all the way up to our Supreme Court stepping in and giving every single county's president judge unique authority. So they essentially said, for county to county president judges, you decide. And what a president judge is for a county is that it is the one individual that is sort of like the principal for the courthouse. They run all of the administrative purposes. They just have a lot more responsibility and tasking for the general business of the courthouse. Each courthouse has one. It doesn't matter if there's only one judge there or if there's 15, and there's different ways that they get selected depending on how many judges are in the court system for that county. So right now, all of the counties, the Supreme Court just issued an order actually earlier this week saying that all of the courts have to open up as of next, right after July 4th, basically. They have to be open again for the public, because some places still are not allowing in-person hearings to move forward. Trials continue to be delayed, and other counties have already opened up and are back to normal business. Do you want to move forward on the next slide? So I'll just talk about the prima facie level again for a second, just to give an example. So for a crime of retail theft, the crime is that a item of property has to be for sale at a business, and you go in and you take the property without paying for it. Okay, so it's actually three separate things. It has to be offered for sale, you have to go in and take it, and you have to not make the payment. Okay, those are elements of a crime. Any single one of those things, if it's not proven, it means that the entire charge is invalid and that officer should never have charged you that way in the first place. So if there's any one of those things that you can argue against at a preliminary hearing, that would be defeating the prima facie, the base level is what that essentially is the Latin for, the base level of the charge. You have to have the whole thing, not just pieces. Next slide. Okay, so this is also giving you some very specific Philadelphia facts, but essentially if a case is held for court at a magistrate level, the next place it goes is into the Court of Common Pleas. And that is for a different level of evidence. So all of the proof beyond a reasonable doubt information and that high burden of evidence, it only exists once the case has passed through the prima facie level at the preliminary hearing. Once it moves forward to the Court of Common Pleas and you have all of your trial rights and you have the ability to review evidence and all of these other protections kick in, that's when that proof beyond a reasonable doubt situation arises. It is also where credibility now becomes king, is that being able to present character witnesses and references and all sorts of other evidence, either at a trial by judge or a trial by jury, is incredibly important, because as we know, whether or not we believe somebody when they're telling us a story might depend on how we view that story. And so all of that becomes relevant now once we get past that preliminary hearing level. Can you get the next one? So the benefit of having a preliminary hearing and actually taking testimony is that you would get to compare that testimony downtown at a trial. So let's say that you have a police officer come in and testify, and he or she refuses to show you the dash cam video. They're like, no, you'll get that in discovery. I don't have to give it to you right now, which is a very common answer. Their testimony can then be compared against the video later and then compared with their own testimony at trial. And when there's differences that are material, and I'm going to highlight that word again, material differences, that can be an incredibly powerful argument as far as their credibility as witnesses. And when I'm saying material, it's not just that, you know, the car was blue and they said it was purple. There's things that when we're looking at it as a common sense idea that we just know in our general day-to-day, not everyone perceives facts the same way. But if an officer is saying that they pulled you out of a car and then did a search, and you can see very well on the video that quite frankly, they searched your car with you in it, that's a very different set of circumstances, and it's very different rules that might apply in those circumstances. And so that can be one very good reason for having a preliminary hearing. I don't think there's a slide in here on it, so I'm going to talk about it just briefly. There is also a way to be what's called indicted. So grand juries can get formed in Pennsylvania where a charge is able to be brought by indictment. And after that happens, you actually don't have the right to counsel at those types of hearings. There's special rules that apply for that to occur in state court. It's the default for the federal government, but for state court, they have to be able to show that the witness is in some kind of reasonable fear, or there's a risk of having evidence destroyed, or there's a reason it has to be secret. Because the hearing itself is ex parte, which means just one party. It's just the government presenting their version of a case without defense counsel available, without the benefit for the jury of any cross-examination, and that a jury then decides, was the prima facie level met? Same result as with the prelim. If it passes through, it goes to the Court of Common Pleas, and then you still have all of your trial rights. So bail motions can be made at any time. Once bail is set, you can revisit it by filing a motion, by orally appearing in front of a judge and making a motion. Pretty much any time you see someone in a black robe, you are able to make a motion to change your bail or modify bail. And that is true for the government as well as the defendant. So if the defendant violates their bail conditions or fails to appear for court in some way, the government is also allowed to ask the court to adjust bail. All right, so obviously this is why I am here. So right to counsel is just so fundamental. It is our 6th Amendment for our federal Constitution. And again, all of our federal rights have been codified in the Pennsylvania Constitution as well. And this is incredibly important. So the right to counsel is so much more than just having someone appear for you, right? It has to be someone that is competent counsel. And that is why if issues arise with your counsel, you're actually able to file separate appeals later on down the line that are called ineffective assistance of counsel claims that ask the judge to say, was my counsel really effective? Was my 6th Amendment right to competent counsel truly put in place? And that's why it's not just having someone show up for court. You know, we all have to go through law school, which is a 3-year process. We all have to pass the bar. We all have to do these certain things and keep up learning credits and all kinds of other stuff. Because it's important that if you're showing up to be the representative of another individual, that you're taking that fiduciary duty seriously, and that it's not just you showing up for court.
I'm just going to interrupt you one more time. Like, you shouldn't just ask an attorney who you know who lives next door to you.
No.
Right? You really should, if you're hiring, you should actually hire an attorney, not just say, can you do me a favor, but hire an attorney who has experience in criminal law. It's really important.
It is. I think that Debbie and I have, very different practice backgrounds. We're both litigators, but there is a huge difference between criminal litigation and civil litigation. And doing criminal litigation, the rules are completely different. The timelines are completely different. And quite frankly, the training is completely different. And same thing with civil, is that I'm not going to walk into my, local real estate attorney's office and say, hey, can you help me out with my traffic ticket? It's just not something that, just because someone is an attorney, it does not mean that they have the knowledge base to handle every single type of case. And so it's important that you interview people when you are hiring counsel.
So if you can't afford counsel, right, that's when the judge can appoint a public defender. And you need to make that clear, because in criminal law, under criminal proceedings, you are entitled to an attorney, whereas in civil proceedings or under civil kind of cases, there's no such right.
Correct. For any civil case, no right to counsel.
Yep.
And I just want to clarify that right on the appointment of counsel. So it will say that you're entitled to counsel, right? That's part of our Miranda warnings. If you can't afford counsel, counsel will be appointed for you. And that phrase beforehand is incredibly important. If you can't afford counsel, so you have to actually qualify financially. There's an interview that happens before a public defender will be appointed to you. You have to financially qualify on an indigency basis for that counsel to be your counsel. And that differs from every single county office. So there are some county offices that say baseline indigency. It's just whatever the federal poverty line is, that's what we're going with. Other times it is that plus 1.5, that plus 2. The office is allowed to decide its own standard for indigency, and that they sometimes will do their own interviews. Other times they actually rely on the court to do the interviewing and review the financial information. It just depends on the jurisdiction that you're in. So these are just a list of all the possible results for a hearing. Generally this is true for everything, is that, a case can be bound over for court, a case can be dismissed because the prosecutor decided not to move forward with it. I would say that by the time you're showing up for a preliminary hearing, that's a less likely result than some. Dismissed for lack of evidence, that would usually mean that a judge is saying you don't have it. And then a remand is a judge dismissing felony charges. So this is more of a Philadelphia thing. Mm-hmm. Usually what we do is when we see remand for everything other than Philadelphia, it means that the Superior Court or the Supreme Court have touched it and sent it back down to be fixed. We don't normally see it as part of the prelim to Court of Common Pleas development. All right, so pretrial motions, the best example that I have of that was the suppression that we had talked about earlier this evening, where you're basically saying that law enforcement collected evidence illegally. So they were either not in the proper location, they didn't have the authority to be there, or they just did something that they didn't have permission or the authority to do. When you're filing a pretrial motion to try to get rid of evidence, that's what you're showing. And what's important about that, and not everyone remembers this, is that it has to be a government actor. So if your family just goes and takes your phone down to the police station and gets you in trouble for something that's on it, even if they didn't have your permission to do that, they're not a government actor, and that's not necessarily going to be suppressed. So those third-party actors happen, unfortunately, more and more now, especially with all of the social media that exists in our society, where things are being turned over by just individuals and not necessarily being recovered anymore by law enforcement. As far as trial, so this is, again, it's specific a little bit more to Philadelphia, what I'm looking at. So the general time frame for a case is that once it gets past the preliminary hearing, you're usually going to have what's called formal arraignment within the next 30 to 45 days. Formal arraignment is essentially a procedural loophole that some counties take advantage of, and it works out really well. And quite frankly, some counties have just been addressing by having people sign papers and filing them online. So it's an opportunity that it fixes your very specific motion forward. So it's the time that your information, your criminal information, has to be filed. You're officially put on notice of what you're being charged with, and all of your timelines for both receiving discovery and responding to it. And discovery is any of the information that you're getting, any of the information that was discovered during your case. You get a copy of almost all of that. And you're able to review it so that you can adequately defend yourself against your assertions. That's the importance of formal arraignment. After formal arraignment, the next thing that's going to happen is your initial, it's called something different in every county, pretrial date, call of the list, miscellaneous court. It is anything other than going in front of a jury for a trial. It could be a date where you're just asking for more time. It could be a date that you're entering a plea. Could be a date that you're asking to schedule a trial. All of those things are options at that initial next court appearance. And then finally would be a trial. For Pennsylvania, we have a rule. It's called Pennsylvania Rule of Criminal Procedure, Rule 600. And what it says is that the government has 1 year, 365 days to bring your case to trial. It also says that if you are detained as a defendant, if you're detained during that time, so you're sitting in a jail, they have to at least present you for what's called nominal bail, so like $1, within 6 months, if they haven't brought you to trial in time. And what's important about that is that it's not just that you haven't gotten to trial. It's that the Commonwealth hasn't done their due diligence and showed basically an effort to expedite your trial process. So if you and your attorney are like, well, I'm just going to ask for a 6-month continuance, that's just not the way that it would work. It has to be that the Commonwealth has failed in their burden and their duty before that would even be possible.
So Petra, what happened in COVID? Because they closed the courts for a little bit.
So we don't know yet, is actually the best answer that I can give you on that. So the question of this Rule 600 timeliness is founded in due process, is that you have a right to a speedy trial because we don't want people languishing and sitting around in jails and not being able to have their reputation restored. And so for COVID, what ended up happening was that because the Supreme Court issued the order that it did, giving all of the president judges this general authority over their courthouses, most of them suspended the rule. And what we don't know yet is whether or not that was lawfully done. No one has been able to send it up as far as it needs to go to litigate. So we don't really have an answer from our Supreme Court yet about whether the way the rules were applied during COVID was correct or not. So we don't know, but that's why the delays happened.
Okay, and I'm just going to say, if anybody has any questions, please feel free to ask them, put them in the chat, and I can, bring them to Petra's attention, because I just saw that we have like 10 minutes to go and we have a few more slides. So, feel free to ask us questions.
Okay, so types of pleas, there are two main ones. So the first is the one that you all think of, I plead guilty. It's my fault, mea culpa, I'm so sorry, you'll never see me again, judge. The other one is actually something that's called a no contest or a nolo contendere plea. And what you're saying is that you're not necessarily admitting to the facts that are charged. Rather, what you're saying is that I agree, Judge, that if this went in front of a jury, the Commonwealth could probably prove this, more likely than not prove this, beyond a reasonable doubt. But I'm not admitting to what they're saying I did, because I just don't agree. It has no difference at all as far as a conviction if you enter a no contest plea or if you enter a guilty plea. It's still a conviction, it's still on your record, it has that same final end result. What it can make a very big difference on, though, is if you have a crime of dishonesty. In immigration court, we call it moral turpitude, and you enter a plea of no contest, let's say bad checks or fraud, or false identification, or access device fraud, something like that, that shows a spirit of dishonesty just in the conduct of doing it. That may not be used against you if you are able to, if you are ever called to court the next time to testify for whatever it is. It can't be used as impeachment evidence the same way that a guilty plea conviction might be able to be used. And it's a very specific and nuanced aspect of those two pleas, where most of the time the reason for the no contest is that you're just simply not agreeing to the facts. And if a judge asks you, is that what you did? You would say no. But you also don't want to run the risk of having to go to trial and the uncertainty that arises from that. It's usually a negotiated plea in that way. Okay, so a jury trial is the biggest unknown for all of criminal court. You don't know who's going to be on your jury until the day that it gets impaneled. You don't even know who's going to be in what's called your veneer, your panel of people. You don't know if it's going to be predominantly teachers, nurses, people with specialized expert backgrounds that might be, someone that you do not want on your jury trial. Or it might be someone that you think is perfect for your jury trial. What ends up happening is that when selecting a jury, you're not actually selecting your jurors. What you're doing is you're able to exclude in two separate ways. One is for cause, which means that a juror is simply not able to sit as a fair and impartial juror, that's the question, and decide the facts of the case. This comes up a lot when you're talking about some kind of a assault case maybe, and someone alleges that they were the victim or had experienced victimization or something else where they're like, you know what? I just don't think I could listen to this and be fair and impartial. That person can then be excused by the court for cause and would not be permitted to sit on that jury. However, you also get the opportunity to do what are called kind of special selected requests. So it's a peremptory challenge is basically what you would be able to do. And you can exclude a juror for pretty much anything that does not violate the Equal Protection Act. As long as you are not violating the juror's right to sit as a juror. And that's the important part here, is that it's the defendant's right to go to trial. But as citizens, we have the right, as long as you're not excluded in some other way, we have the right to sit as jurors. And so that is actually what's being asked, is as long as you're not interfering with that as counsel, both the government and defense counsel are able to exclude a set number of jurors from their panel. And then your actual jury, the 12 people plus extras are always added in, are just the people that are left after you've excluded everyone. So it's a very different kind of process than I think most people are aware of when you think about it. But those 12 people then have to be able to reach a decision, a unanimous decision, in order for a verdict to be entered. And so that means that it could be a guilty to all charges. It could be a not guilty to all charges. It could be a guilty to just one charge and a not guilty to all the other charges. And it could be any combination that you can think of in that way. It's really up to a jury to decide whether or not the government has proven their case beyond a reasonable doubt. And sometimes there are instances where there's a little bit of a burden put onto defendants in very special circumstances called affirmative defenses. which is only required for a very reduced burden. And then as long as you meet your reduced burden as the defendant, it flips back to the government and they have to disprove your defense beyond a reasonable doubt. But again, it's just a very specific instance where something like that would arise. So after a verdict is handed down, which is a guilty verdict of some kind, and that could be guilty, it could be guilty by reason of insanity, which is essentially guilty but mentally ill. Any kind of conviction that gets handed down, the judge's next step is to schedule a sentencing hearing and decide what your penalty is going to be. Kids and adults are handled completely separately, and juvenile court is its own topic altogether. There are cases where children are tried as adults. There's very special rules in Pennsylvania for when that's able to happen. But the distinction between it is that for juvenile court, you're asking a question, is this person in need of treatment, supervision, and or rehabilitation? In sentencing, you're looking more at penalty. So it's how do we correct the behavior? How do we address the needs that exist? It's a very different question that the court is asked to answer. And normally it's something where there are requirements by Pennsylvania statute that something called a pre-sentence investigation occur. Counsel for the defendant is allowed to waive that if the court will allow it, but that is up to the court to decide. And then at the time of sentencing, absent a mandatory minimum existing, and that is a sentencing rule that is actually set by our legislature. Absent that existing, our judges actually have complete discretion as far as what sentencing should look like for the individual. It's something that's incredibly important for criminal justice, is individualized sentencing for each individual. And again, the only exception to that is a mandatory minimum sentence.
Petra, I know we are at 8 o'clock, so I think we just have 1 or 2 more slides left.
Okay.
Okay.
I just got a knowledge quiz.
I mean, the rest, I would say we don't need to do the appeals, maybe. Let's just do this post-trial, post-sentence.
Sure. So
Right.
After a sentence is put in place, there's very few things that you're able to appeal if you've entered a plea. If you've entered a trial, you're able to appeal anything that's happened at trial. But if you entered a plea, the only thing you're allowed to challenge is whether or not the court had jurisdiction of your case, whether or not your sentence was lawful, which means that as long as the judge stayed within your maximum possible penalty for the charge, as long as that happened, it's probably a lawful sentence. And then also whether or not your counsel was effective. You actually do have an option of challenging that as well. We had talked about that too. It's just a very limited scope of what is even permissible for appeal after a plea. I mean, you actually end up having to sign off in every jurisdiction. You end up having to at least sign off or acknowledge that you understand that your appellate rights are limited after entering a plea.
Okay. So I know that there have been a number of questions in the chat that I have sort of answered, but not to the extent I would like to. Is the only way to say that. We are not allowed in this process. We're not giving legal advice. We're not specifically being retained by you. So that I know there were some specific questions in here about certain situations. But what we can do is we will send out the the PowerPoint to those who have participated. You can follow up with any questions and we can see if we can, provide some answers. But I want to thank everybody for attending. Petra, I want to thank you so much for joining us. You were amazing. And this was really a wonderful evening and informative evening, and we very much appreciate it. So have a good night, everybody, and thank you.